Good evening. My name is Adrian. I'm a professor of psychiatry in the School of Medicine here at UCI. It's my pleasure to welcome you all to this evening's debate. It's a very exciting event. I'm just going to spend 1 minute giving you a brief history of how this came about. A few months ago, I was driving to work, listening to NPR, and I happened to hear a familiar voice, Dr. Kheriaty, an esteemed colleague, talking about his perspective on Prop 128. I came to work, I congratulated Dr. Kheriaty on his media appearance, and then asked him if he would be interested in actually lecturing to the psychiatric faculty on the issue. Now, one thing led to another, and before we knew it, it quickly became apparent that instead of a lecture, it would be much more informative to have a debate. And instead of limiting this to the Department of Psychiatry, it would be much more informative to open it to the public at large. Now, in the morning, it looked like a great idea to tell Dr. Kheriaty to lecture to the faculty, but now it was much more complicated because I needed to find a debater that was going to be able to hold the opposite position. It turned out that it was not a very difficult process because, lucky for all of us, one of the most articulated speakers on the right to life is the dean of our own School of Law, Dr. Chemerinsky. And do you know what it took to get Dr. Chemerinsky on the team? 1 email and half an hour of wait. And his email was, Dr. Prater, I mean when and where. So that was easy. The only other piece that we needed to have was a knowledgeable and balanced moderator. And I knew who that was going to be, Dr. Doug Haynes, who is the director of the Medical Humanities program here. Seemed to be a wonderful choice, but I didn't know if he was available. Do you know what it took to get him on the team? 1 email and about 25 minutes of wait. So I just wanted to thank them all for our experts for offering so graciously their time and their expertise. This is a very important topic, literally a life and death topic. I welcome you all, looking forward to a great debate. And now I'd like to introduce our next speaker, Dr. Al Bennett, who is the Vice Provost for Academic Initiatives here at UCI and former Dean of the School of Biology. Dr. Bennett.
Thank you very much, Adrian. On behalf of the University, of Chancellor Gilman, Provost Lavernia, and the Office of Academic Initiatives, I want to welcome all of you. We're thrilled with the turnout and with the interest that this topic has generated. Let me speak briefly about the initiatives themselves. Universities, almost by definition, are places where there are a lot of people that are doing things in the universe and all of the different areas of thought, which is great to have that kind of expertise looking outward. But the internal divisions of the university can make things difficult about getting people from different fields together and working on a common topic. So here at UCI, we have initiated a program called Academic Initiatives. These are competitive initiatives that are put together by faculty and proposed for support from the university. And they undergo a rigorous examination, and they are required to have representation from many different units on campus, ideally from the humanities, from the social sciences, from the sciences and engineering, and from the professional schools. That would be ideal. And to bring all of that together on a common topic, on a common focus, where you have faculty working instead of in their individual areas on a common problem. One of our initiatives is Medical Humanities, and that involves, again, it's an unusual combination to have humanists talking to people within the medical school, but that's actually common. Here we have, we have programs that are involved in that. But the initiative itself seeks to have something even broader and to bring in people from law, from social ecology, from arts, from humanities, as well as from the medical school, to talk about the humanistic aspects of the use of medicine, treatment of patients, and looking at things from not only a diversity of different fields, but also a diversity of different cultures. So we're very proud of this initiative, and what I'd like to do now is introduce the director of that initiative, Dr. Douglas Haynes, who is a professor of history and a vice provost for academic diversity on campus, and he is also the director of the Medical Humanities Initiative. Doug?
Thank you, Al. I want to add my welcome to those of Vice Provost Bennett and Professor Adrian Prater to the University of California, Irvine. Like other great universities, UCI plays an important role in facilitating the public understanding of pressing issues of the day. This evening's debate on doctor-assisted suicide and physician aid in dying is undoubtedly one of those issues. At present, there are 4 states in the United States, Oregon, Washington, Montana, and Vermont, with laws that permit licensed physicians to legally prescribe life-ending drugs to competent adults with terminal illnesses. Another 20 states have or are considering similar legislation. There are several lawsuits that are also working their way through the various state and federal court systems. The right to die or to life is part of a broad spectrum of issues about human existence, spanning life and death. The question before us is not so much when people die as who has the right to make the determination to end their life, and under what conditions in a society bound together by laws. As the reporting and commentary on the End of Life Option Act, now known as Assembly Bill X2-15, formerly Senate Bill 128, abundantly shows, the answer to these questions raise a host of other fundamental issues. Some of these issues include the scope of our rights as citizens, the capacity of our ethical principles as individuals, and the place of morality in our public policy. Whether you have come to this evening's debate with answers to these questions or not, it is our hope that each of us leaves with a greater appreciation of the issues before us. The format of this evening is designed to serve this purpose, and I want to briefly describe it. The debate will consist of approximately 40 minutes with dedicated allocations of time to opening statements and responses. Our timekeeper, Stephanie Yoshi, who's down in the front, will alert speakers at 3 minutes and 1 minute before their time has expired. Another 25 to 30 minutes will be reserved for questions from the audience that have been submitted online through the registration process, as well as collected from the index cards this evening. And as you entered, you were offered index cards and pencils, and they'll be collected in the period of the debate. At this time, I have the privilege to introduce my 2 colleagues, whom I respect enormously. Speaking on behalf of the Right to Die position is Erwin Chemerinsky. Erwin Chemerinsky is the founding dean and distinguished professor of law and Raymond Pikey Professor of First Amendment Law at UC Irvine with a joint appointment in political science. Prior to assuming this position in 2008, he was the Alston and Byrd Professor of Law and Political Science at Duke University from 2004 to 2008. And before that, was a professor at the University of Southern California Law School from 1983 to 2004, including as Sidney Ermis Professor of Public Interest Law, Legal Ethics, and Political Science. He is the author of 8 books, most recently, The Case Against the Supreme Court, published in 2014 by Viking, and more than 200 law review articles. He frequently argues appellate cases, including in the United States Supreme Court. Dean Chemerinsky is a graduate of Northwestern University and Harvard Law School. In 2014, National Jurist magazine named Dean Chemerinsky as the most influential person in legal education in the United States. To my right, soon to be right, and speaking in opposition to the right to die, is Aaron Kheriaty. He is Associate Professor of Psychiatry and Director of the Program in Medical Ethics at the University of California, Irvine School of Medicine, where he also serves as Chairman of the Clinical Ethics Committee at the UCI Medical Center. Dr. Kheriaty graduated from the University of Notre Dame in philosophy and pre-medical courses and earned his MD degree at Georgetown University. He is the author of several books and articles for professional lay audiences on bioethics, social science, and psychiatry. On the issue of doctor-assisted suicide, he has published articles in the Wall Street Journal, the Orange County Register, The First Things, and conducted print, radio, and interviews on CNN, NPR, NBC, CBS, Fox, and Fusion. Dr. Kheriaty was invited to speak on Senate Bill 128 to the California Medical Association and the UC Center in Sacramento. He testified before the California Health Committee against SB 128, and his work was cited in the California Senate floor during the debates. I now would like to ask our worthy advocates to come to the debate. As the debaters agreed beforehand, Dean Chemerinsky will lead off the debate with his opening statement after he's mic'd up.
All set, Doug?
Ready to go.
Good evening. I want to thank the UC Office of Academic Initiatives for putting on this debate on such an important topic. I'm truly honored to participate. In March of 1993, my father was dying of lung cancer. The doctors told him that there's nothing left that could be done to treat his disease. The hope was that he would die at home with the help of hospice care. An unexpected complication developed. The tumor spread to his arm and was blocking circulation to the arm. His arm became grotesquely swollen. Went to the hospital, and the doctors explained that there's a real danger that gangrene would soon set in. They suggested his arm could be amputated. He said that he realized that he only had a short time to live, and it didn't matter whether it was the cancer or gangrene that killed him. He was admitted to the hospital. On Monday afternoon, March 15th, the doctor came to see him. My dad said to the doctor that he was either awake in an excruciating pain or drugged in unconsciousness. My dad said that he knew he had only a short time to live, that he was never going to get out of the hospital bed, and he asked the doctor to simply put some additional morphine in to end his life. The doctor said he couldn't do that. My father was a persistent man. In fact, those who knew both of us would say I got my stubbornness from him. And my dad persisted in the conversation with the doctor. My dad was completely lucid, competent by every definition. Finally, the doctor just said no and walked out. For the next couple of days, anytime a doctor came into the room, my dad was conscious, he asked the same thing. It was a horrible week for my father. It was a horrible week to watch. My dad's breathing became increasingly labored. As he had said to the doctor, either he was awake and complained of excruciating pain, or he was drugged into unconsciousness. 4 days after his request, on Friday, March 19th, my dad passed away. I will never understand what interest the state of Indiana had in prolonging his life those 4 days. I will never understand what interest the state of Indiana had in keeping my dad nearing death with dignity. I'm here tonight to argue that there should be a right to death with dignity. Specifically, what I want to argue for is that competent terminally ill patients should have the right to physician-assisted death. I'll develop my argument by making 2 points. The first point is that the rights to autonomy and privacy should be seen as including a right to death with dignity, a right of competent, terminally ill patients to be able to have physician-assisted death. Autonomy and privacy are regarded as fundamental rights. They're regarded that way under our Constitution. They're regarded that way in society. Relatively long ago, in 1928, Supreme Court Justice Louis Brandeis, in Olmstead versus United States, said, there is no more precious right than the right to be let alone in the most important decisions of our lives. The Supreme Court, in many different cases and in many different contexts, has recognized autonomy and privacy as fundamental rights. The court has said, for example, that there's a fundamental right to marry, to procreate, to custody of one's children, to keep the family together, of parents to control the upbringing of their children, to purchase and use contraceptives, to abortion, to engage in private, consensual, same-sex sexual activity. Why are these regarded as fundamental rights, even though they're not mentioned in the Constitution? Because they are so integral to personhood, to privacy, to autonomy. I would argue to you that the right to death with dignity is also a key aspect of autonomy and privacy. After all, in terms of personhood, what is more basic to autonomy than the right to choose whether to live or to die? Here, of course, what we're discussing is terminally ill patients. They will die, and die soon, as my dad did. The question is, should the right to die with dignity, or should their life be prolonged against their wishes? Now, the reality is that terminally ill patients will often be able to exercise a right to end their lives. I listed for you the aspects of privacy and autonomy protected by the Supreme Court. I intentionally omitted one. The Supreme Court has also said that competent adults have a right to refuse life-saving medical treatment. In fact, the Supreme Court has even held that competent adults have a right to refuse food and water, knowing it will end their lives. This was a Supreme Court decision in 1990 in Cruzan versus Director of Health Services. It involved a woman by the name of Nancy Cruzan. She was in a terrible car accident. She was in a persistent vegetative state. Her family said it was her wishes to end food and hydration, to not live in that way. And the Supreme Court ruled that competent adults have such a right. So when we're talking about competent adults who are receiving medical care that's keeping them alive, food, water, a ventilator, they have the right to order it be turned off. That, after all, if it's done by a physician, is physician-assisted death. And those who have the physical means to commit suicide can do so. Often, it's quite gruesome for them and their family, but they can do so. But what about someone like my father? Someone who was in a hospital bed, too weak to commit suicide, not yet on artificial life support. I think of a woman whose name was Brittany Maynard. She was a young woman with terminal cancer, a brain tumor, and she decided that she wanted to end her life and die with dignity So she went up to the state of Oregon to do so. Shouldn't that have been her right? Or I think of my father-in-law, who was in the last stages of an illness, who wanted to die, and simply ended his life by refusing to eat or take water. He suffered greatly from that. Why did the state put him through that? Why didn't it let his last days be ones of dignity? Why didn't it allow him to die with dignity? And so my argument to you tonight is that basic humanity, fundamental considerations of personal autonomy should include this right of competent, terminal patients to have physician-assisted death. The second point that I want to make tonight is that possible abuses of the right are not a reason to refuse to recognize its existence. I have followed very closely the debate here in California. I have followed the debates in courts and legislatures across the country. Inevitably, the argument against physician-assisted death is that to create such a right risks abuses. It's not to deny what I've just said, that autonomy and personhood should include the right. It's that we have to prevent abuses. But what I want to argue to you tonight is that the danger of abuses aren't a reason to recognize such an important, such a fundamental right. What I'd argue to you first is that abuses are unlikely to occur. We now have the experience of a number of states where there is physician-assisted death. Oregon was the first state to create such a right by initiative in 1997. As Professor Haynes pointed out, Washington, Vermont, and Montana are other states with such a right. The experience in these states shows that abuses rarely occur. I've researched this extensively, and I have not found instances of people being pressured to participate in physician-assisted death. In fact, the statistics from Oregon show that it really is a choice of individuals. For example, since Oregon adopted its law in 1997, 1,173 individuals have received prescriptions for lethal doses of drugs to end their life. You find out that many of them took such prescriptions, but many of them did not take such prescriptions. In 2012, for example, 116 individuals received prescriptions, but 85 of them took them and died. 122 people got such prescriptions in 2013, 71 took them and died. So it's apparent as many people want the prescriptions there, should they want to end their life, but not everyone takes those prescriptions. And this is exactly what they should have the right to do, the ability to make that choice. The second thing I would say with regard to the danger of abuse is that safeguards can prevent abuses. If the concern is that this might be abused, people might be pressured to end their life, then create safeguards. We are not here tonight to debate the specifics of the California bill. Those specifics can be changed in the legislative process. But consider some of the specifics that exist in the current draft. 2 physicians must confirm that the individual has 6 months or less to live in all likelihood. Also, in order for physician-assisted death to exist, if this becomes a law, the dying person must make 2 oral requests 15 days apart and then a written request. I actually think that's far too restrictive, as I think of my father's situation. The person who would be choosing physician-assisted death must be informed that other alternatives exist, including palliative care and hospice care. There must be 2 witnesses to the person's choice to receive the prescription for a lethal dose of medication. The person can withdraw the request at any time. Now, if the argument is that those safeguards are insufficient, then let's talk about what other safeguards to create. But the fact that the right might be abused is a reason to create protections, not a reason to deny the existence of the right. But I'd argue to you, third, that I actually think legalization will prevent abuses and prevent suffering. The reality is that physician-assisted death occurs now. I did a debate on this topic a number of years ago. My opponent said that he was a doctor, and he and his colleagues would often just add morphine at a patient's request. Leave it to the doctors, no need for the law to be involved. I would much rather have the process regulated with safeguards than leave it unregulated. Also, the reality is that people facing terminal illnesses will often try to commit suicide on their own. They will often try to calculate what's a lethal dose and take it, or try to end their life in another way. This then creates great suffering, sometimes for them, often from their family. It often means that the attempts are unsuccessful, leading to more suffering. Given that they've chosen to end their life, wouldn't it be better to do so in the very best way? But I also think that this argument about abuses commits a logical fallacy. It's the fallacy of composition. It says because sometime there might be an abuse, always deny the existence of the right to everyone. That can't be so. As I said, if our concern is abuse, let's regulate it to prevent it. But let's not deny those who are competent, who are terminally ill, of the ability to die with dignity. I think of how we treat our pets in this society. If a dog or a cat is facing a terminal illness, if a dog or a cat is going to be suffering, we'll end the dog or cat's misery. We'll provide the lethal injection. And of course, this isn't even a conscious choice of the dog or cat. We're making it for the dog or cat. What we're talking about tonight is competent adults. What I'm saying to you is, shouldn't we treat our loved ones with the same humanity and compassion that we treat our pets? Shouldn't we allow competent, terminally adults the right to death with dignity? Shouldn't we allow a right to vision-assisted suicide? I think the answer is clear. I think the law should recognize such a right.
Thank you, Dean Chemerinsky. Now, as per the agreement, Professor Kheriaty, your opening remarks.
In the past 8 months, we've seen 21 attempts to legalize assisted suicide in various states. 0 laws have been passed so far. In the last 30 years, we've seen over 100 attempts, with only 3 of these laws or ballot initiatives succeeding. Time and again, we see the same pattern. There's an initial wave of enthusiasm for the idea based upon cases that appeal to our compassion, like the case of Brittany Menard or the case of Professor Chemerinsky's father. But on matters of public policy, we need to look not just at one case or even one type of case. On this issue, we need more than abstract ivory tower legal arguments. We need to look beyond imaginary constitutional emanations and penumbras. We need to examine what this actually means on the ground for real patients in the real world. As these debates unfold and as the public takes a closer look at the issue, the initial support for assisted suicide legalization wanes and the polling numbers drop. We saw this back in 2012 in Massachusetts. The same voters who re-elected Barack Obama gave the thumbs down to doctor-assisted suicide. Compassion and Choices, the assisted suicide advocacy organization formerly known as the Hemlock Society, saw a 40-point victory margin evaporate in Massachusetts on Election Day in spite of millions of dollars in campaign spending. And recently we've seen the same pattern in California with Senate Bill 128, which encountered bipartisan opposition and stalled in the Assembly Health Committee. That was the 4th time such a bill or ballot measure has failed in California. Proponents, like Professor Chemerinsky, like to point to the Oregon experience as the gold standard. In fact, each new legislative proposal has been based on the Oregon law. So I also want to take a closer look at the experience in Oregon, and I'm going to sketch both prudential and principled reasons to oppose legalization of doctor-assisted death. First, assisted suicide is discriminatory and it risks abandoning vulnerable individuals. As a psychiatrist, I've evaluated and treated literally thousands of patients who wanted to end their life or who made an attempt on their life. People whose life stories are every bit as heartbreaking as Brittany Menard's and whose reasons for wanting to die might appear at first glance to be just as compelling. But even among terminally ill patients, a request to die is nearly always a cry for help. It's a kind of canary in the coal mine. It's a distress signal indicating that something in the patient's condition at the medical, the psychological, or the social level is not being adequately attended to. And we know from clinical experience and from research that when comfort or relief is offered in the form of more adequate treatment for depression, more comprehensive palliative care, better pain management, these requests typically vanish. In the Netherlands, for example, the request for hastened death is withdrawn in 85% of cases where the patient's symptoms are better controlled. You see, suicidal individuals typically do not want to die. They merely want to escape what they perceive to be an intolerable situation. And they see this as their only escape hatch. Among terminally ill individuals, a request to die is associated with a potentially treatable clinical depression in 60 to 70% of cases. And yet, alarmingly, in Oregon, less than 5% of the individuals who have died by assisted suicide were ever referred for psychiatric consultation or psychological evaluation prior to getting the deadly drug, to rule out the most common causes of suicidal thinking. This number is decreasing every year. It was 3% last year. Consider the case in Oregon of Michael Freeland, a man with a 43-year history of intermittent depression and prior suicide attempts before the onset of his medical illness. The doctor who legally prescribed him the deadly drug, so this was not an abuse of the safeguards in the law, did not deem it necessary to refer him for psychiatric consultation, and he died. Proponents have steadfastly refused to consider a requirement for psychiatric screening. Based upon what we know about suicide risk factors, this is a form of medical negligence. A law allowing assisted suicide for some individuals creates two cohorts of patients who no longer enjoy equal protection under the law and who no longer receive equal medical care. Assisted suicide causes doctors to discriminate based upon the patient's health status. So Robin Williams walks into my office saying that because of a terrible illness, his addiction, his life has become unbearable, and so he wants to end it. And naturally, I intervene to try to protect him. Then Brittany Menard walks into my office saying that because of a terrible illness, her cancer, her life has become, or she anticipates will soon become, unbearable. And so she wants to end it. And not only do I not intervene to protect her, but I actually engage in helping her to kill herself. These two incompatible approaches to dealing with suicide cannot long coexist side by side in medicine and mental health care. Something's going to have to give. Second reason, this practice ignores what we know about individuals who want to end their life. Suicide is typically an impulsive and an ambivalent act. A journalist tracked down the few dozen individuals who have survived jumping off the Golden Gate Bridge, which is the #1 suicide spot in the world. And he asked them, what was going through your minds in the 4 seconds between when you jumped and when you hit the water? Every single one of them said the same thing. They said, I regretted the decision to jump, with one man saying, quote, I realized that all the problems in my life that I thought were unsolvable were actually solvable, except for having just jumped. To abandon such individuals under the guise of respecting their privacy or their autonomy is socially irresponsible. Suicide completion generally requires not just intent, which typically waxes and wanes over time, but also easy access to the means. People tend to fixate on one particular method or one specific plan, and if that method or plan isn't available, they typically don't choose an alternative method. They choose instead to live. I had this experience recently with a 79-year-old man who requested from me doctor-assisted suicide. But he gave up entirely on his plan to end his life when he discovered that neither I nor my colleagues at UC Irvine would provide this for him. Third reason, these laws will have negative consequences on public health, aside from any potential abuses. Assisted suicide advocates claim that this is a purely private decision, an exercise in personal autonomy that won't affect anyone else. But there is a well-studied social contagion aspect to this behavior that cannot be ignored. In spite of the wholly inadequate system for monitoring and reporting on doctor-assisted death in Oregon, the data that we do have is quite distressing. After suicide rates had declined in Oregon in the 1990s, they rose dramatically between 2000 and 2010. In the years following the legalization of assisted suicide in '97. By 2010, suicide rates in Oregon were 35% higher than the national average. Now, this correlation alone does not prove causation, but a rigorous study that will be published next month by my colleague David Jones of Oxford University controls for other potentially confounding or state-specific effects that could account for this rise. And his study demonstrates that the permissive assisted suicide laws in Oregon and Washington have caused at least a 6% rise in overall suicide rates, assisted and unassisted, in both of those states. And this finding actually should not surprise us, because we know that suicide is among the health-related behaviors that tends to spread from person to person through social networks and social contexts, up to 3 degrees of separation. So my choice to end my own life affects not only my friends' choices, but my friends' friends' friends. We know also that publicized cases lead to clusters of copycat cases. This is known in social science as the Werther effect. A Swiss study in 2003, for example, showed evidence for suicide contagion following media reports of doctor-assisted death, doctor-assisted suicide. No man is an island, do you see? What's more, the law itself is a teacher. Our laws shape cultural attitudes towards certain behaviors. They influence social norms. And doctor-assisted suicide laws communicate the message that under especially difficult circumstances, some lives are not worth living. This message will be heard not only by those with a terminal illness, but by anyone who's struggling with the temptation to end his or her own life. We've seen in jurisdictions that have legalized this the problem of doctor shopping. Very few practicing physicians are willing to write prescriptions for lethal drugs or even participate in these evaluations. After all, it runs contrary to everything that we're trained to do, and it violates the foundational ethical principle of first, do no harm. Where it's legalized, doctor-assisted death therefore becomes a kind of marginalized cottage industry within medicine. In Oregon, a very small number of physicians write a disproportionately large number of the prescriptions. So if you want treatment, you go to your physician. If you want to die, you go to a doctor that you've never met before who is referred by an assisted suicide advocacy organization. In fact, this is exactly what happened to the first woman to die by assisted suicide after the law was passed in Oregon. Her personal physician and a second consulting physician both refused to end her life, judging that her request was motivated by an untreated depression. Compassion and Choices then got involved and referred the woman to their preferred doctor who did provide the deadly drug. In 2003, a spokesman for this organization publicly said that about 75% of those who had died under Oregon's law had done so with their organization's assistance. Fifth reason, which safeguards can also not prevent. Economic and social factors will exert pressure on vulnerable individuals. We cannot ignore the economic forces at work in medicine. We cannot ignore subtle pressures that may be placed on individuals at the end of life. Illness makes us vulnerable, and nothing makes us more vulnerable than a terminal illness. Such individuals are exquisitely sensitive to any suggestion that they are a burden on others, that they are not worth caring for, that they're too costly to pay for. Consider the cases of Barbara Wagner and Randy Stroop in Oregon. Both received letters from their public insurance, the Oregon Health Plan, denying coverage for potentially life-extending treatments that their physicians had recommended. In Barbara's case, the chemotherapy would have cost about $3,000 a month. In both cases, the Oregon Health Plan offered, in the very same letter, to pay instead for the $50 assisted suicide pills. You see, as soon as this option is introduced, it immediately becomes the cheapest and most expedient way of dealing with complicated and often expensive situations at the end of life. This is, I would submit to you, a deadly mix in a healthcare system that's currently under tremendous pressure to lower the costs of care. Finally, let's look at the demographics on both sides of this debate. Supporters of doctor-assisted death, by and large, constitute a homogeneous elite. White, upper and middle class, well-insured, well-educated, with family members who can help them navigate our complex healthcare system. While these people may be the most likely to want to avail themselves of this option, they are also precisely the folks least likely to be harmed by the bill. We don't see widespread support from the Latino or African American communities. We don't see support from the uninsured or the underinsured, or from those who are economically or socially marginalized. We certainly don't see support. In fact, we see strong opposition from the disability rights community. Because what these folks want is access to decent health care. They need Medi-Cal to pay for good palliative care. They need hospitals in their communities not to close down. So why are we looking to Oregon? When have we ever looked to Oregon, which is a lily-white state without the social and cultural complexity of California, for our public health policy? In closing, our patients, every patient, deserves hope. And hope comes in many forms that go beyond just a medical cure. We need to communicate to each and every patient, we will accompany you through whatever difficult process you're going through. We will not abandon you. We will continue to care for you even when cure has become impossible. Our patients deserve this kind of hope. But the proposal to legalize doctor-assisted suicide offers them only a counsel of despair.
Thank you, Professor Kheriaty. Before we turn to the set responses, I want to encourage those of you who have index cards and pencils and are interested in writing questions to write them now and pass them to the aisle, and they'll be collected and then delivered to me for our question and answer segment to the debaters. Now I'd like to turn to Dean Chemerinsky for his response.
Ultimately, the question is who decides? If a person is terminally incompetent, does that individual get to decide whether to die with dignity? Or is it for the state through its law to make that decision for the person? I believe who decides should be answered by allowing each individual to have the chance for death with dignity, for terminally ill, competent patients to be able to have physician-assisted death. I made 2 points. First, that the rights to autonomy and privacy include a right to death with dignity, a right of terminally ill, competent patients to choose physician-assisted death. I said to you that the Constitution long has been interpreted to protect aspects of privacy and autonomy as fundamental rights. Dr. Kheriaty doesn't deny that. I said nothing is more precious to autonomy and personhood than the ability to choose whether to live or to die. Notice Dr. Kheriaty doesn't deny that either. In fact, none of his arguments go to the fundamental question of, is it an aspect of autonomy and personhood to be able to choose death with dignity? So what does Dr. Kheriaty say? He begins by saying that 21 states considered this recently, but none have adopted it. There's only 4 states that have right to physician-assisted death. But that doesn't begin to analyze why these states didn't adopt such a right. I think if you look at it, you find there was an intense campaign from some religions against having such a right. There were scare stories told, and often was a lack of understanding of the right and the safeguards. So the failure of the states to adopt it just shows we need more debates like this and more education of people so that they won't be persuaded by the scare stories. Second, he says that allowing such a right is discriminatory. I listened closely, but I'm still not sure who allowing such a right would be discriminatory against. In fact, not having such a right is discriminatory. Those who are on artificial life support have the right to end that life support. They can have the doctor turn off the respirator, turn off the ventilator, end the food and water. It's those who are not, who are denied the right to physician-assisted death. In fact, that's why the United States Court of Appeals of the Second Circuit in Vacco versus Quill found that laws that prohibit physician-assisted death are discriminatory and deny of equal protection. Third, he says, a request for physician-assisted death is regarded as a distress signal. It's a symptom. And he talked about suicide. Now, people who attempt suicide, like jumping off the Golden Gate Bridge, later regret it. First, I strongly disagree with his use of the word suicide and characterizing it as such. What you're dealing with here is terminal patients who will die soon. The question is, how will they die? Do they have the right to choose to die with dignity, with physician-assisted death, or just from what comes with their illness? Second, he characterizes those who make this choice as just depressed. Again, I strongly disagree with that characterization. As I think of my father who knew he had just days to live, or I think of my wife's stepmother who died an agonizing death over the last few days of her life, I don't think it was depression that caused them to ask their doctors to end their life. I think it was a quite rational choice that they wanted to die with dignity. So I don't think stories about who jumps off the Golden Gate Bridge have any relevance to this. And I think it is insulting to individuals who choose to die with dignity to say they're just depressed. Third, he says physicians will discriminate among their patients. I think what we'd agree with is that if there's a right to death with dignity, physicians should counsel their patients. They should advise their patients of all of the available options: palliative care, hospice care, what can be done through pain relief. But also one of the options should be a prescription that the person can take to end his or her life. Fourth, Dr. Kheriaty says there's negative consequences to society. That if there's physician-assisted death, this will cause a contagion and this will increase suicides. And he points to statistics from other states. First, a correlation never proves causation. Everyone who ate pickles in the Civil War is now dead, but that doesn't mean that pickles cause death. I think if you examine the studies, you'll find that there is not a causal relationship between allowing physician-assisted death and an increase in suicide. But there's an even more fundamental problem with that argument. We never deny people a constitutional right because others might abuse it. We don't deny some women the right to abortion because others will abuse that right. We don't deny people freedom of speech because it might lead to other bad consequences in society. If you accept my argument that a crucial aspect of personal autonomy is the right to die with dignity, then let's do other things to prevent those suicides. But it's not a reason to deny a right to those who should have it. Fifth, he says the law is a powerful teacher. We agree on that. And I think what the law should teach here is that we respect the autonomy and personhood of each individual to make the key choices for his or her life. Sixth, he says there's physician shopping. But so long as people are making a voluntary choice, that isn't something to concern us. Seventh, he says there's economic and social pressure. It's interesting that in all the studies that have been done in Oregon, in Washington, in Montana, in Vermont, there's no evidence of people being pressured into a position of suicide. But if there is that, then that's a reason to create better safeguards, not a reason to eliminate the right. Now, he gave a horrifying example of what an insurance company did. Let's have laws to prevent insurance companies from doing that, not a reason to deny the right to physician-assisted death. Economic and social pressures are a reason for safeguards, not a reason to deny the existence of the right. And so then I argue to you, second, that possible abuses of the right are not a reason for failing to recognize it. I said abuses are unlikely. I said what's interesting is the Oregon experience shows there's not abuses. Oregon shows that many people get the prescriptions, but only some of them take them. He says that in Oregon, only less than 5% of the people have received psychiatric care. I would have no problem with saying that one of the requirements is that before a person is given a lethal dose of prescription, there has to be a referral to a psychiatrist. But that's a reason to have referrals to psychiatrists. That's not a reason to deny physician-assisted death. He gives an example of an individual who was given the prescription without a psychiatric referral. Give the psychiatric referral, but that's not a reason to deny it. I said safeguards can prevent abuses. And I went through the long list of safeguards that exist in the California bill. Safeguards that would prevent people from being pressured. Safeguards that would make sure that it was truly a knowing and voluntary choice. He said those who support this are demographically white, upper-class people. Latinos and African Americans tend not to support this. That doesn't tell us anything about whether the right should exist. Notice he hasn't given you any evidence, because none exists, that African Americans or Latinos are more likely to be pressured into physician-assisted death. He hasn't shown you any experience in many of the other states that shows that there's a discriminatory effect. We've never defeated a bill just by saying this is a bill that's supported by one group as opposed to another. What you have to do is evaluate, is there a right? Can we prevent safeguards? Who lobbies for it isn't a reason against it. Third, and I think quite importantly, I say that actually legalization will prevent abuses and suffering. In reality, doctors do engage in physician-assisted death now. Isn't it better to be regulated? People who are facing terminal illnesses will choose to try to end their own lives. It often increases their suffering. It often increases the suffering for their family members. Shouldn't they have the right to choose to end their lives with dignity? And finally, I said, the fact that some might abuse it isn't a reason to keep everyone from having the right. If the concern is abuse, if the concern is pressure, adopt laws that prevent that. I have no doubt that if someday I'm in the situation of my father or my stepmother, I would want to end my life. I'm not saying that out of depression. I'm not saying that out of call for help. I'm saying that at a certain point when one is terminally ill, it's a rational choice, not a pathological one to say, it's time for my life to be over. My father, on Monday, March 15th, was as best I could tell, though I'm not a psychiatrist, not depressed. My father was completely competent and totally lucid. My father knew he just had days to live, and he knew that he was either going to be awake and in great pain or drugged in unconsciousness. He knew it was becoming increasingly difficult for him to breathe. He also knew that it was very hard for all of us to watch him suffer. He made a completely rational, totally conscious choice that he'd rather have died on March 15th than 4 days later on March 19th. And what Dr. Kheriaty has never answered, what I've never heard anybody answer is, what interest did the state of Indiana have in keeping him alive those 4 extra days? Ultimately, as I said, the question is, who should decide? Should it be for the individual to make the choice for his or own life? Or should it be the state through its criminal laws to decide? I think when you focus on it that way, the answer is clear. There should be a right to death with dignity. There should be a right for competent terminally ill patients to choose physician-assisted death.
Thank you, Dean Chemerinsky. Professor Kheriaty, your response.
Dean Chemerinsky believes that we can enact laws with sufficient safeguards to prevent harms. In theory, that may be interesting. In practice, it's actually never been done. He claims that people are doing this already, so why not legalize it so that we can regulate it? But of course, people violate criminal laws already. Every single criminal law in the books is being violated. But that's no reason to legalize theft or fraud. Professor Chemerinsky claims that the right to choose the timing and circumstances of my death and, furthermore, to enlist the medical profession to assist me with that, because suicide in California is not illegal. What is illegal is to help someone else to kill themselves. He believes that this is a fundamental aspect of autonomy. But Professor Chemerinsky, a dead person has no autonomy. Exercising my autonomy in order to end my ability to act autonomously is self-contradictory. Life itself is the basis, the grounding and precondition for any free and autonomous human action. How then could destroying my life be a suitable exercise of my autonomy or a basic fundamental constitutional human right? Professor Chemerinsky paints this as one small step in expanding already existing palliative care options. It is not. It's a radical upending of the practice of medicine. The proponents of assisted suicide would have us erase the key ethical distinction between allowing a disease to take its natural course or providing adequate palliative care to manage symptoms and directly intervening to deliberately cause the death of the patient. But there's a vast gulf between the ethical act of allowing natural death and the unethical act of intentionally inflicting death. Surely Professor Chemerinsky knows, in fact, he's written about these decisions, but he neglected to mention that Vaco v. Quill went all the way to the Supreme Court, where the decision unanimously was that New York State's ban on doctor-assisted suicide and euthanasia was to be upheld. The court rejected the claim that letting patients die by removing life support was the same thing as killing. This was the plaintiff's argument. 9-0. A twin case that same year, 97, Washington v. Glucksberg, came to the same 9-0 unanimous decision, where the Supreme Court held that the Due Process Clause of the 14th Amendment does not protect the right to assisted suicide. Assisted suicide is not a fundamental liberty interest, and we have two good precedents set in constitutional law that clearly articulate that. Advocates like Professor Chemerinsky don't like the word suicide. They want to call it death with dignity. They want to call it physician aid in dying. They want to say this is not really suicide. And they present two arguments. The first argument presented by Compassion and Choices is that the means employed, taking a deadly drug, are, quote, nonviolent and peaceful. But of course, by this logic, if I commit suicide by carbon monoxide poisoning or deliberate drug overdose, we would also, I suppose, not call that a suicide. This is plainly absurd. The second argument, which on the face of it might appear more plausible, is, look, the person's going to die anyway. Right? But of course, this wouldn't be an adequate defense in a homicide trial. I think this attempt to manipulate language and to do an end run about the hard realities at work here is irresponsible. The definition of suicide is clear. It doesn't depend on the particular means that are employed. It doesn't depend on the patient's health status. And advocates who are honest say, yeah, we have no problem with this word. We just want you all to know that we think people should be able to choose to take their own life. I want to explain why we should be concerned about a slippery slope. And this is a principle that's not a practical argument, and it's an empirically based argument. The central arguments for doctor-assisted suicide are twofold. The argument from autonomy and privacy, and the argument from pain and suffering. And Professor Chemerinsky has very ably presented both of those arguments. One of the chief problems with both the pain and suffering and the autonomy and choice arguments is that they are too expansive. They do too much. They take us too far. For these arguments would justify death on demand for anyone on the basis of choice, or for anyone on the basis of reports that they are suffering intolerably. If there exists a right to assisted suicide, why would it be restricted to only those with a terminal illness? Someone with a more slowly progressive illness will certainly point out the law's basic unfairness, right? Why should I be denied this right? Just because my illness won't cause my death for 3 years or 5 years or 10 years? In fact, I deserve this more because I have to suffer longer with this debilitating condition, whereas that guy's suffering is going to be over in a couple of months. Of course, on the basis of the pain and suffering and the autonomy and choice arguments that Professor Chemerinsky has presented, we would have to accept this reasoning. Once we adopt the principle that assisted suicide is reasonable and acceptable, then the fences that legislators try to erect around it, the safeguards that Professor Chemerinsky wants in the law, having 6 months to live, being over the age of 18, having mental capacity, these things are inevitably arbitrary. And these restrictions will eventually be abandoned, as the situation in Belgium and the Netherlands demonstrates. In Belgium, assisted suicide was recently granted to a 24-year-old physically healthy woman suffering from depression, to a prisoner suffering, quote, psychological anguish due to my imprisonment, and to a person who is dissatisfied with the results of their sex reassignment surgery. In the Netherlands, assisted suicide was recently granted to a woman because she didn't want to live in a nursing home but had no other housing options. By 2012, 1 in 30 people in Netherlands died by euthanasia. By 2013, in the Flanders region of Belgium, fully 1 in 22 people died by euthanasia. The Groningen Protocol in the Netherlands now allows euthanasia for disabled infants. And last year, Belgium legalized euthanasia for terminally ill children of any age. When these countries first legalized the practice, the applicant had to check an incurable illness box before the lethal injection was given. Today, when indicating the reasons for wanting to die, applicants for assisted suicide in these countries may check a box that says, tired of life. 28% of the requests based upon this tired of life criteria were granted in the Netherlands in 2013. A study published this year in the Journal of Medical Ethics showed alarmingly high rates of involuntary euthanasia in Belgium. That is to say, doctors are giving these lethal injections without the patient's request and without the patient's consent. This occurs in over 1,000 cases every year, and most of these patients are suffering from dementia. They're vulnerable, clearly vulnerable to abuse. We see evidence here not only of a practical slippery slope, that restrictions will be difficult to enforce or monitor. More than this, we see a relentlessly logical slippery slope. Again, because once we accept the principle that this is reasonable, then the restrictions become arbitrary. If death is judged to be of benefit for those who can request it, why would we withhold it for patients in similar circumstances just because they're incapable of making this request? just because they're incapacitated. Now you might think, look, Kheriaty, this could never happen here, right? That's somewhere over on the moon, like across the Atlantic. But why not? The logic will relentlessly push us in this direction. The only reason that proponents in Oregon haven't pushed further faster is because at present it's not politically expedient, because their argument rests on the supposed safeguards in the law. So I'd like to challenge Professor Chemerinsky to answer this question. Where exactly would you draw the lines? Who would qualify for this, and on what principled basis would it be allowed for these individuals but not others? And finally, how are these proposed restrictions not arbitrary and groundless in light of the expansive argument from autonomy or the expansive argument from pain and suffering that you've presented?
Thank you, Professor Kheriaty. I'm going to use the moderator's prerogative. I'm going to give Dean Chemerinsky 2 minutes to reply, if you choose.
Sure. I didn't expect that. I'll go back to the question that I posed. Who gets to decide? I said that it should be part of a person's autonomy to be able to choose to end his or her life. Dr. Kheriaty said, well, it can't be your autonomy to end your life because then you're ending your autonomy. That doesn't make any sense. If I am alive, if I am conscious, I have autonomy. And I should be able to make the fundamental choice to be able to end my life. And I think the fundamental flaw in his position is he's never explained to you why it shouldn't be a part of autonomy, why it shouldn't be a part of personhood, for the person to be able to decide to end his or her life, rather than make the state, through its criminal laws, prevent that. But my second argument was that the possibility of abuse doesn't justify denying the right. It just justifies regulation. And what's interesting is, for all of what he said, he's never shown you abuses in Oregon or in Montana or in Vermont or Washington where this exists. He hasn't given you examples of people being pressured into physician-assisted death. Now, he ended by talking about the experience in Netherlands and in Belgium. And he said, the problem is, once you create the right to physician-assisted death, how are you going to cabin it? The problem, though, with slippery slope arguments is that you don't have to accept the slippery slope. What we're discussing tonight is, should terminally ill patients, where 2 doctors have said they have less than 6 months to live, have the ability to choose to end their lives? If we believe that right exists, and no others should have the right to physician-assisted death, let's draw the line right there, as the California bill does. And if we say it's wrong to allow anybody else to have the right to physician-assisted death because we're afraid of abuses, we've ended the slippery slope. We said this is the group that should have it. But again, as I've said over and again, the fact that there can be abuses doesn't mean that we don't give the right. It means that we regulate the right. And so we make sure through regulation we never get to Netherlands, we never get to the Belgium situation. It hasn't occurred in Oregon, it hasn't occurred in any other states. Individuals who are competent in facing a terminal illness should get to decide for themselves. It shouldn't be for the state to choose for them.
Thank you.
Okay. I don't think Professor Chemerinsky answered my question, except to say maybe terminally ill individuals, but I guess everyone who wants to exercise this fundamental right autonomously. So I'm not sure that I still know where you stand in terms of how you would draw the lines on this law. But you asked me to show a case of pressure and abuse. So consider the case of Kate Cheney, an 85-year-old woman in Oregon. Her physician denied her assisted suicide, judging that she lacked capacity due to her dementia. A consulting psychiatrist documented in her evaluation that it appeared that the patient's daughter was pressuring her to request assisted suicide, and that the daughter was, this was written in the chart, somewhat coercive. Nevertheless, a managed care insurance company, I won't say which one, but it's one that does operate here in California, found her another doctor who did prescribe the lethal drug, and she died. The Oregon Health Division has publicly stated it has no resources and no authority to investigate such reported cases of abuse. So again, when we see how this plays out on the ground, when we look at the actual experience of what happens when you enact this law, we see 2 things. One is that we can't prevent abuses, and we haven't prevented abuses. And 2, that the logic continues to push us in the direction of expansion. The other issue here that I think is of fundamental importance is we have to see what this does to the public's trust in medical professionals. Received a letter from a palliative care physician in Oregon in response to an opinion piece that I wrote. He said, I would never prescribe this. I would never suggest this to a patient. And yet patients are coming to me saying, Doc, I only came to you very reluctantly because I thought that this is what you were going to give me. Patients need to know that physicians will use our knowledge and skills only for the purpose of health and healing. Otherwise, trust, which is fundamental to the doctor-patient relationship, is going to erode.
Thank you, Professor Kheriaty. We're going to move now to the next phase of our public debate. Questions from the audience that were collected as well as from online during the registration process. And as per the early agreement, Professor Chemerinsky will receive the first question, and we'll follow with Professor Kheriaty. Dean Chemerinsky, I'm reading a question from the audience. Does the state have a legitimate interest in recognizing and protecting the autonomy of the physician, especially those who have fundamental moral or religious disagreements with the practice?
Yes. I think that any physician who doesn't want to provide a prescription for a lethal dose doesn't have to do so. I think just as any physician who doesn't want to perform abortions doesn't have to perform abortions. The law never requires that a doctor perform abortions against his or her conscience. Doctor would not be required by the law to provide such a prescription. Now, that doesn't mean that the patient can't go to another doctor to get such a prescription, and that might lead to what Dr. Kheriaty calls physician shopping. But if there's a terminally ill patient who competent said, I want to die with dignity, and his or her doctor won't give the prescription, that person should be able to go to another doctor to get that prescription.
Thank you.
Doctors don't practice in isolation. We practice within a healthcare system. And we ply our trade in relation to a public that's impacted by everything that's done in medicine. So anything that erodes the trust of physicians in their patients is going to impact me and affect me in my clinical practice, regardless of whether or not I choose to participate in that corrosive or nefarious practice. Why would we permit something that's going to erode the practice of medicine that runs contrary to the foundational principles that have governed medicine since the time of the Hippocratic Oath? There's another principle in the law which Professor Chemerinsky failed to mention. A supposed right for one group or cohort of individuals cannot introduce an undue burden on another group or cohort of individuals. This is a principle that goes all the way back to John Locke and certainly has a place in Anglo-American jurisprudence. So I hesitate to venture into the realm of jurisprudence and constitutional law with a man of Professor Chemerinsky's status, but I think we have to look at this not just as a hyper-individualistic sort of issue, but as a social issue. And we need to see how this is going to affect healthcare as a whole.
Professor Kheriaty, the next question is for you. You stated that your Hippocratic Oath lets you do no... I'm just reading the question.
Love that one.
You stated that your Hippocratic Oath lets
now I know what you think of me, Doug.
He's a psychiatrist. It was a slip. Lets you do no harm. In the case of terminally ill patients in prolonged, excruciating pain, how might you respond to the assertion that by denying life-ending drugs, you are in fact violating that very Hippocratic Oath?
Great question. Thank you. Clearly, not everyone today dies a comfortable and peaceful death. I'll be the first to acknowledge this serious problem and to acknowledge that medicine needs to do much more, much better in this regard. That's why I'm working with leaders in palliative care in California to introduce positive, constructive legislation to improve access to and education in palliative care. That's why I'm leading an initiative at UCI Medical Center on advanced care planning so that patients can sit down earlier with their physicians and have conversations about what they want and what they don't want and make their own decisions at the end of life. The problem is not that we're unable to treat pain or other medical complications of terminal illnesses. In fact, never before in history have we had better medical technology for doing this. At UCI Med Center, we see all kinds of emotionally anguishing and complicated situations at the end of life. I'm often consulted on these as chair of the ethics committee. But with our excellent palliative care service, with our excellent acute pain service, we don't see patients in our hospital dying in unremitting pain. We don't see patients spending their last days with untreatable seizures. Good medicine can treat these complications. The founder of the hospice movement put it very well, Dame Cicely Saunders. Last days need not be lost days. Every day can be a gift, even with a terminal illness. There's people in the audience who are living that and demonstrating that by their lives. I think the real problem is that the best of what's available, the very best palliative and end-of-life care, is not made widely accessible to all Californians. So we should therefore be focused on improving access to the best care possible for everyone, instead of pushing this pseudo-solution, this kind of Band-Aid proposal of legalizing doctor-assisted death.
Reply?
Please. I think the last statement by Dr. Kheriaty really speaks volumes. He says that every day is a gift. He may believe that, but there are people at the very end of their life who don't believe that, who can't believe that. I had an uncle who died of ALS, and I think were he able to speak at the end, he would have told you the last days of his life were no gift at all, and nothing that could have been done could have possibly made them a gift. And in response to the prior question, Dr. Kheriaty also said something that speaks volumes. He said this is a corrosive and nefarious practice. Here we fundamentally disagree. I believe in dignity of individuals and autonomy of individuals and letting them make their choice. He says that it decreases the trust in physicians if there's physician-assisted death. I'm not sure what more decreases trust in physicians. When I watched the physician walk out of my father's room saying no, I lost a lot of respect for the medical profession. My wife watched a doctor say he couldn't assist her stepmother die with dignity. She lost a lot of trust in the medical profession. So no matter what we do, certainly have an effect on perceptions. I believe that the role of the physician is to reduce pain and suffering. Most of all, I think the physician, like the lawyer, is there to respect the autonomy of the individual. As a lawyer, what I do is explain to my clients the choices that they have. I have a client who's on death row who chose no longer to appeal. That's his right. My role as a lawyer is to explain the choices and to respect those choices when they're made. I obviously believe in palliative care and it to be available, but I also believe that there's some instances where palliative care isn't the solution. When somebody's in a situation like my father was either being conscious in excruciating pain, struggling to breathe, or sedated unconsciousness, I think it's rational to choose to die. I've now known a few people who have died of ALS. I understand why somebody in the last stages of that disease would say, every day isn't a gift. If there's somebody with that disease who believes that it is, they should choose to continue to live, and nothing should pressure them otherwise. But those who say they want it to be over should have the right to death with dignity.
The next question is for Dean Chemerinsky. If you believe in your tenets of autonomy and privacy fully, upon what basis do you limit this right to die to only those whose suffering is due to a terminal disease, when suffering can destroy dignity and personhood in the absence of a terminal diagnosis?
I think it's an enormously difficult question. I think what we focus on first is, should those with terminal illnesses have the right to death with dignity? And I think I've made the case for that tonight. We can then come back another night, if the UCI Office of Academic Initiative will have, and we can debate whether such a right should be extended to others who are facing great pain and suffering, who may want to choose to exercise such a right. And then the debate will be, can we prevent abuses in those instances, or should we allow autonomy and privacy there? But to me, that's a separate question. We don't need to accept the possibility of others having this right to say that those with terminal illness should have it. Or to put as I have tonight, we should grant the right to these individuals and then discuss whether it should be extended to others sometime in the future.
Why?
So Professor Chemerinsky claims that we need this option to deal with situations of intolerable pain and suffering. But again, let's look to the experience of what happens when we enact these laws. In Oregon, most patients who died by assisted suicide did not cite concerns about pain and suffering as their motivating reason. Only 25% of individuals cited inadequate pain control, or even the fear of inadequate pain control. Those two categories were lumped together in that number. Far more people cited a perceived loss of autonomy, or worries about losing their dignity, or the fear that they would become a burden on others. Illness and disability does not rob a human being of dignity. Every human person has dignity because they're a member of the human family. The perceived loss of dignity that some people experience with illness is very often due to the way in which other people react to them, the way in which others, in subtle ways, might pull away from them. And this fear of abandonment is paramount when someone is suffering. What this law does is to legitimize that form of abandonment. I agreed to do this debate, and it was probably a bit foolish of me. I was joking with Professor Chemerinsky that I think he was arguing cases before the Supreme Court when I was still in diapers.
That doesn't make me feel better.
I meant this as a comment on... That was a comment about my age, not about his.
You can't direct age assertions to the opponent.
But I agreed to do it because I think it raises fundamental questions for us as a society, right? It raises the question of just what sort of society do we want to become? Do we want a society driven by a kind of hyper-individualism? Or do we want a society that's driven by solidarity and by love and care for those who are marginalized, disabled, or sick?
The next question is for you, Dr. Kheriaty. Would you approve of the right to choose physician-assisted death for a person with a terminal illness in chronic pain if, and there are three conditions, a psychiatrist treated the patient for depression, 2, a physician has explained all of the options, palliative care, etc., and 3rd, the cost of the options were equal?
No. Okay. And we can stack up even more conditions and more safeguards there if we want to. I think on the basis of what I've said, I would not want to legalize that or permit that for all of both the prudential and the practical reasons that I've already presented. So I feel like I've covered that ground. I can elaborate more, but I'm not sure what else I could say that hasn't been said in relation to the issue of just trying to stack up more and more safeguards. Again, in theory, people really want to do this. They really want to think there's a group of patients out there that ought to be able to get this, right? And they ought to be able to enlist the entire medical profession in being a part of this, right? That's really what's at issue. That's really what's at issue, right? But every time I write a prescription for a deadly drug, let's say the patient takes it. Well, I'm as responsible for that as I would be if I gave them the injection myself. I'm morally just as responsible for the prescriptions I write as for the procedures that I do directly. And if they don't take it, then we have a deadly drug floating around out there that just about anyone can access. And Professor Chemerinsky may scoff at concerns about suicide and social contagion, but they are in fact real. The empirical evidence does in fact support them. And suicide is now a public health crisis. It's the second leading cause of death among college-age students. It's the third leading cause of death among adolescents. Do we really want to enact something that we now have empirical evidence and grounds to believe is going to worsen that public health crisis?
Dean Chemerinsky, a reply.
Please. There's so much in that statement. Here's the question you have to ask yourself. Could a rational person facing a terminal illness choose to end his or her life? if you were facing, can you imagine a situation of an illness that you were facing where you'd say, it's time, I'd rather no longer be alive? If so, then I think the answer to the question of this debate should be clear in your mind. Now, the law already allows individuals to cut off medical treatment, to have the respirator, the ventilator, food and water turned off. I assume Dr. Kheriaty's position would say we shouldn't allow that either, because that could be abused. And yet what that means is that those who are on artificial life support have already the right to physician-assisted death. What we're just saying is, shouldn't others who are not on artificial life support have that? Dr. Kheriaty asks the right question. What sort of society do we want to live in? But his characterization is unfair. He says, do we want, quote, I'm quoting his words, hyper-individualism or a society with solidarity and compassion? That's loading the deck. Obviously, I want a society with compassion. We both support compassion equally. But I also want a society where individuals are able to make the key choices for their own lives. And no choice is more important than to live or die. He says that suicide can be a social contagion, that there's an epidemic of suicide among college students. I challenge him or anyone to show that there's any relationship between suicide among college students and allowing terminal patients to have death with dignity. What we should do is find ways of preventing suicide among college students. In all of the ways that campuses know how to do, we'd support it. But that's not a reason to keep terminal ill patients from having the right to death with dignity. He's right. It is a question of what kind of society we want to live in. To me, that's a question of who should get to make this choice. Should the terminal ill patient be able to decide, or should the criminal laws of the state be able to decide?
The next question is for you, Dr. Dean Chemerinsky. Are capital murder death sentence convicts allowed euthanasia? Those condemned to death, are they allowed euthanasia?
A capital murder defendant, in one sense, has the right to state-imposed euthanasia. He or she could choose just not to appeal any further. One of the most famous examples of this is Gary Gilmore. After the death penalty was resumed in 1976, he decided he was going to pursue no further appeals. His mother tried to litigate on his behalf, and the court wouldn't allow it. And he was executed by firing squad in Utah. That really was state-imposed euthanasia. Now, with regard to those who are on death row, we never know when their death sentence is going to be carried out because there are such delays in the process. I guess they're terminal in one sense, but that's obviously not what we're talking about here. What we're talking about here is people who are facing terminal illnesses. And so if there was somebody on death row who was facing a terminal illness, he or she should have the same right to death with dignity that I've argued for everybody else.
Thank you. Professor Kheriaty, you have a reply?
So Professor Chemerinsky has suggested in some of his remarks that he thinks this law is only a first step, right? And that the proposal in California would not go far enough. In fact, as he mentioned, it wouldn't have applied to the case of his father, which is clearly the case that grounds his thinking in this regard. But Professor Chemerinsky, it's not clear to me why you would deny this to a terminally ill individual, or rather to a death row individual who did not have a terminal illness on the basis of the arguments that you have presented. Certainly this person could claim as much psychological suffering as anyone else on the planet. Let's not step back from the implications of your arguments. Let's find out clearly where this is going to take us. And if it's going to take us down the road that has been traveled already by Switzerland, where they'll come to your house and dispatch you with a suicide van and cart your body away, or by Belgium and the Netherlands, as I've described. If we don't want to go down that road, then let's not cross this bright line. Let's not ask and enlist physicians to change their role from becoming healers to becoming killers.
The next question is for Dr. Kheriaty. What about the negative cost to society that comes with forcing relatives and loved ones and relatives to do what physicians will not? We need only look at the history of the AIDS crisis to know that family and friends were charged with ending their loved ones' lives over and over again?
Well, I object to the way that entire question is framed. And in fact, I find that question remarkably offensive. The notion that a family member would not want to have to do this, therefore, I should do this, seems rather startling, does it not? See, that's one of the things that's going on here. Now, this is going to sound facetious, and I don't mean it this way, but we can ask the question, why not truck driver-assisted suicide? And we sort of cringe at that notion. But the fact is, it doesn't require any special knowledge or skills to dispatch another person. You could learn how to do this in the course of a weekend. You know, how much to give, and the anti-nausea medication to make sure they don't throw up the handful of pills that they have to take to make this thing work, and all the rest of it. It doesn't require a medical degree to do this. So why do we ask physicians to do this? Because physicians in our society still have some form of moral authority. Right? We still carry some of that with us in spite of everything. And so this is an effort to legitimize a practice that all of us instinctively find repugnant. Right? So that family member who doesn't want to assist their loved one with suicide, then coming to me and saying, Dr. Kheriaty, you should have to do, the law should require you to do something that I don't want to do, that I would find anguishing and painful to do, that I would be bothered morally to do. If it troubles you, don't you think it ought to trouble me as well?
Your reply, Dean Chemerinsky.
We've all heard the phrase mercy killing, where a loved one puts someone out of suffering. And I assure you, as I watched my father, I thought of whether I had the moral obligation to do what he had requested. And perhaps it was only my lack of courage and cowardice that caused me not to do so. He says, we can't have physicians transferred into ending people's lives. Physicians already end people's lives. When physicians turn off the ventilator or the respirator, or end the medication that's necessary to keep blood pressure up, physicians are ending people's lives. So he says, why physicians and not truck drivers? Well, what we're dealing here with is medical conditions, so that's why physicians are involved. And physicians have the ability to give prescriptions that can end people's lives without suffering. The problem is now that without physician-assisted death, it is loved ones or individuals who are trying on their own to commit suicide, which involves far more trauma. And Dr. Kheriaty keeps saying, well, where do you draw the line? If we allow this, we're crossing a line that's going to lead to the Netherlands and Belgium. It isn't that horrible. So let's agree that we should never have what's the Netherlands and Belgium. But I know no reason why allowing physician-assisted death in California for terminal ill patients inescapably takes us to what the Netherlands and Belgium have. If we all condemn what's in the Netherlands and Belgium, we'll never get there. Oregon has had physician-assisted death since 1997, and it hasn't had the slippery slope that Dr. Kheriaty says is inevitable. That's because it's not inevitable. If this should be a right, create this right. If we don't want in other instances, reject it in those instances. But the possibility of bad other actions isn't a reason for denying people the right to death with dignity.
The next question is for you, Dean Chemerinsky. Can you provide a distinction between suicide and death with dignity?
The reason that I reject the use of the word suicide here and choose physician-assisted death is that we are talking about terminally ill patients who are going to die. California says there have to be 2 doctors who certify they're likely to die within 6 months. And even if medical science is uncertain, I can tell you of so many instances of people who knew they were in the last days or weeks of their lives, and all the doctors would have said so. And I believe that in that instance, it is physician-assisted death, but I think it's a mistake to call it suicide because they would die very soon anyway. But this doesn't have to turn on semantics. If you want to call what I'm talking about tonight physician-assisted suicide for terminal ill patients, that's fine. The question is, should those facing terminal illnesses who are competent and lucid have the right to choose to end their lives? The question is, can you imagine a situation where you think it would be better for you or a loved one to make that choice? That's why I believe such a right should exist.
Thank you. Dr. Kheriaty, a reply.
Yeah, I want to respond to Professor Chemerinsky's claim that he's made a couple of times that withholding or withdrawing life support is equivalent to physician-assisted suicide. Of course, physicians can withhold or withdraw life support, let's say a ventilator or dialysis, knowing with a good deal of certainty that this will probably result in the patient's death, that the patient's disease will take its natural course. But of course, we do this not with the intention of killing the patient, and intention does matter in the law, as Professor Chemerinsky knows well. Because we're not trying to kill the patient, we're trying to allow them to live out their last moments without the burdens of useless or excessively burdensome treatments. So my decision, let's say to give a high dose of morphine, could potentially cause the patient respiratory depression. I might know that that could potentially hasten their death. But medical ethics, as well as the Supreme Court in the two decisions I've mentioned, clearly states that that's acceptable, right? A decision can have a side effect that's unwanted, but that's no reason to forego it. If I stop the ventilator and the patient continues breathing, which often happens, right? We don't know with certainty what's going to happen when we turn off the vent. I do not then consider that to be a treatment failure. I don't then intervene to cause the patient's death. By contrast, in doctor-assisted suicide, if the patient takes the pills and they don't die, then I have most certainly failed in my purpose. For the only reason for giving the pills is to cause the patient's death. That is not a medical act. It is not an act of healing.
We're rapidly coming to the close of the question and answer segment. We'll have two more questions, and the second to last is to you, Dr. Kheriaty. Many people choose their position on this issue based on their religious ideas about death. Aren't we supposed to be free from being governed by the religious ideas of others?
None of the arguments that I've presented tonight rest upon a religious foundation. Proponents, the narrative that they're presenting now is that Senate Bill 128 died because of opposition from religious people. The California Coalition Against Assisted Suicide is among the most religiously, politically, and ideologically diverse group of politically active individuals that you'll find anywhere in California. There's individuals from across the ideological spectrum. There's individuals that are motivated by religious concerns. There are individuals that are motivated by concerns that have nothing to do with religion. In a civil society, all of us come to the table with our own concerns and our own metaphysical presuppositions, and we make arguments. And we try in public venues to make publicly accessible and publicly compelling arguments. I think Professor Chemerinsky and I have both tried to do that tonight, and I think arguments can certainly be made that doctor-assisted death or physician-assisted suicide is harmful to individuals in society that are not based upon religious concerns and not based upon theological principles.
If a doctor gives a patient too much morphine, knowing it will end the patient's life, that is physician-assisted death. And Dr. Kheriaty said that physicians will sometimes give too much morphine, knowing it will end the patient's life. If a doctor turns off the respirator, knowing that in all likelihood the patient is going to die, that's physician-assisted death. If the patient is kept alive through artificial hydration and nutrition, and the doctor cuts it off, the doctor knows that the patient will be dying, that's physician-assisted death. If a patient is kept alive only through dialysis, the doctor knows that ending the dialysis will end the patient's life. All of those exist today. All of those are forms of physician-assisted death. Dr. Kheriaty wants to talk the law. I'm glad to do that. In the law, intent is often defined as taking an action with knowledge of foreseeable consequences. When the doctor takes all of those actions, it's with knowledge of foreseeable consequences. What's interesting is all of those forms of physician-assisted death exist and have long existed, but they haven't caused the slippery slope. They haven't caused the abuses. The only problem is it means that those who are on artificial life support have a right to physician-assisted death, to order these things be turned off, this treatment ended. It's others who are not on artificial life support who don't have this. To me, that's a form of discrimination. We can talk about where does the opposition to physician-assisted death come from. I do believe that it's, at least the intense opposition, is coming from religious opposition. That's fine. Those who are religious have the right to express their views as well. But I think when we think of this in terms of what we regard as fundamental rights in our society, rights of autonomy and personhood, there should be a right to death with dignity.
The final question goes to Dean Chemerinsky. What social norms would be affected by legalization of physician-assisted death?
I think if you look at Oregon, in Montana, in Vermont, in Washington, I don't think you've seen a major change in social norms of the social fabric. Undoubtedly, physician-assisted death involves many social norms and social values. I've talked a lot about the value of autonomy and of personhood, which I think rank very high when we talk about our values in this society. We both are talking about the sanctity of life. That's a very important norm. It's a very important value. I think we equally respect the sanctity of life. I think where we disagree, as I keep saying over and again, is the question of who should make the choice in society. Should the terminally ill patient be able to choose for himself or herself, or should we leave it to the criminal laws of the state? That's really where we disagree.
Finally, Dr. Kheriaty, you have the last word.
So I mentioned among the social norms that will change is the attitude that we take to our own life and the attitude we take to those who are ready to despair of their lives. I mentioned the Werther effect. Right? When there's a publicized case, there are copycat cases. Professor Chemerinsky challenged me to cite an example of a young person who is influenced by doctor-assisted suicide. So I'll cite the case of a 14-year-old girl from Chile who recently made a YouTube video begging her government for assisted suicide. She admitted that the idea to end her life came from watching Brittany Menard's YouTube video. She later changed her mind after meeting another young person suffering from her same disease, cystic fibrosis, who conveyed a message of hope and encouraged her to persevere. That person demonstrated what social scientists call the Papageno Effect. So the Werther effect comes from a novel by Goethe, where the protagonist, thwarted in his romantic pursuits, shoots himself with a pistol. And the novel caused a rash of copycat cases in Germany. When it was published, the authorities wanted to ban the novel. The Papageno effect comes from Mozart's opera, The Magic Flute, where the protagonist is tempted to commit suicide. But instead, he finds ways to cope with adversity through other strategies. His planned suicide is averted by three child spirits who remind him of alternatives to death and things that he continue to live for. Our decisions affect one another. Our laws communicate the value of life or the disvalue of life. So we can go one of these two directions. We can go the direction of Werther, of encouraging people in these circumstances to go ahead and just end it, or we can go in the direction of the Papageno effect, where we can have a positive influence on one another. We can help those who are struggling, who are suffering, who are in pain, whether physical or psychological, to regain a sense of hope and purpose, even in their last days and even in their last moments.
At this time, we've reached the end of our scheduled debate. I want to take this opportunity to warmly thank my colleagues, Dean Chemerinsky and Professor Aaron Kheriaty, for their expertise, insight, and passion in advancing the public understanding of the right to die. I hope you'll agree with me that we all benefit from reasoned debate and informed discussion, even if we disagree. Although our debaters exhibited their talents flawlessly, I would be remiss if I did not acknowledge the several individuals who contributed to the making of this evening program. They include Professor Adrian, the Professor of Psychiatry, Al Bennett, Vice Provost for Academic Initiatives. I want to warmly thank the team of career staff in the Office of Academic Initiatives in transforming this event from an idea into reality: Susan Coons, Diana Laughlin, and Andrea Whelan. I also want to thank Daniela McClehy, the Medical Humanities Initiative graduate student researcher, as well as several UCI medical students who volunteered. Please give them all a hand. The turnout for this event this evening underscores the interest in a host of related issues. I want to draw your attention to future programs that the UCI Medical Humanities Initiative is mounting in connection with the School of Law and the School of Medicine. Those posters are available outside. Please join us at these upcoming events. They are free but require registration. Check the Medical Humanities Initiative website for more information. Finally, I want to thank each of you here and those who are watching on our live stream feed. Your engagement with this issue is critical to the development and shape of our public policy. Above all, your attention and attendance underscore the centrality of an engaged citizenry in advancing the singularity of the experiment of the United States. What we do tonight is seek to fulfill life, liberty, and the pursuit of happiness. Thank you and good night.
It was a pleasure.
Thank you.